other factors the court might consider in deciding not to do a 50-50?
Yeah, I think there's many different factors. I think a big one is...
Hello, everyone, and thank you for joining me again today. My name is Holly Mullin, and I am the managing partner at Sterling Law Offices. I have with me today special guest attorney Nikole Messerschmidt. Nikole is a senior partner in our Madison office, and she has previously joined me on other episodes to help all of you understand the nuances of family law, given her pretty significant practical experience that she has working with divorcing couples in Wisconsin. She has a wealth of knowledge that she has generously shared with us. So thank you again, Nikole, for joining us.
Thanks, Holly. Appreciate it.
And today we are going to dive into a discussion that is present in literally every divorce that we have in Wisconsin, which is property division. And what I mean by that is all of the assets, all of the debts that are involved in a divorce case need to be awarded to somebody. And there's some presumptions in the law, there's some factors that we consider that can help people understand what that might look like in their case. So today, I would love to break that down and help our listeners understand how that works in Wisconsin. So, Nikole, could you just tell us, in Wisconsin, when we say property division, Wisconsin we hear about as being a community property or a marital property state. Can you tell us what that means?
Yes, Holly. So we are a community property state, which means that everything kind of starts at 50-50. I tell my clients all the time that regardless of how long you're married, right, whether you brought property or debt to the marriage, whether you acquired it during your marriage, whether it's individually titled or jointly titled or even titled with yourself and someone else. Technically, everything is deemed marital to some extent and subject to the starting point of like a 50-50 split. And from there might be arguments to kind of tip the scales in one person's favor or the other.
Yeah, and I'm sure you have shared this experience that I have had, which is the wide eyes that we get from clients when we say the exact sentence you just regurgitated that you've probably said in hundreds of consultations. Yes, and it's like, wait a minute, but it's only in my name. Wait a minute, I owned that before the marriage, right? And it's like, yeah, welcome to Wisconsin. It is, you marry somebody for all they're worth or not worth, and that includes everything that they brought into that marriage. So when we talk about property, we're not just talking real estate. What other versions of property do we have in Wisconsin?
Lots of other ones. Your bank accounts is a property, your house, your retirement accounts, any personal property, right? Like, so that boat you might have or that, super cool Trek bike that you might have might be something that needs to be divided. And also debts, right? Like credit card debt, tax debt, any other secured or unsecured liabilities.
Got it. Thank you for clarifying debts. Yeah, that's an important one when we talk about property division. That's all the pluses and the minuses.
Yes.
It's good to consider that. So in Wisconsin, you mentioned everything comes in with the presumption of 50-50 marital property. Is there any exclusion to that?
Yes, to some extent, gifts or inheritance. If an individual receives that during the marriage, that potentially is something that isn't subject to the equal division that we just spoke about, so long as it hasn't been commingled, put into other assets with your spouse. So it's hard to kind of trace back where that came from, for example.
So when you say commingling, you're saying basically mix together. So
Yes.
If you have an inheritance, I'm just going to make up numbers. You have $10,000 that you got from your grandmother. What should or should not be done with that money?
Yes, I think both we can answer, right? What should be done with that is to put it in account solely in your name and try not to use it, especially if you're going to move forward with a divorce sooner rather than later. Don't add your spouse's name on it. Don't add any additional marital income to it. If you liquidate it and you spend it on a marital asset or put it towards renovating your house that you own jointly with your spouse, those are things that you may not be able to get that money back.
Got it. So separate means separate. You're not, even though it's a $10,000 check, and you get divorced 5 years later and you say, but no, I know it was $10,000. I can prove it was $10,000. Shouldn't I get $10,000 back out of our joint checking account? Your answer is going to be,
Yeah.
sorry, you
Yeah.
mixed it together and you
Yes.
can't unmix it. Good advice. I mean, for those, of course, contemplating a potential divorce, if you're in a happy marriage and you want to mix your inheritance together, there's nothing wrong with that. But this is specifically if you're looking to keep separate individual property. So, is there a way to opt out of these rules in Wisconsin?
Sort of. I mean, I guess you could get a prenuptial agreement or a postnuptial agreement, right? But those always come with potential pitfalls. You don't necessarily know if that agreement is going to be upheld at the time the divorce happens. And there's other provisions that might chip away at that, from the date that you guys sign it, the parties sign it, to when it might be implemented in the future.
So, prenup, postnup, something where you could at least consider if you wanted to try and circumvent the rules in Wisconsin, but probably best to get some attorney advice before making assumptions about how bulletproof those kind of agreements are, is the takeaway there.
Yeah, for sure. And I think for clarification too, just in case people listening don't know, prenuptial agreement is an agreement before people get married, and postnuptial is after they're already married.
Yeah, that's a great point, because I think a lot of people don't even realize postnuptial agreements are a thing,
Right.
is that you could still enter into a property agreement after the marriage takes place. You already mentioned this presumption of a 50-50 split. Is there ever a deviation from that? Is there ever a reason, aside from gifts and inheritance, is there any other factors the court might consider in deciding not to do a 50-50?
Yeah, I think there's many different factors. I think a big one is perhaps potentially, assets brought to the marriage, and also like marriage length, right? So, for example, if someone was married for 6 months, right, and they brought $1 million to the marriage, I don't have a magic crystal ball. I couldn't predict what a court would for sure do, but chances are that more likely than not, a court's not going to divide up that $1 million account that an individual had prior to marriage, even without a prenuptial agreement, for example. I don't think a court would seem like that other person wanting half of that would get a windfall just because they were married for a very short period of time to that individual. Maybe it'd be different if we're talking about 30 years down the line, right? And parties are getting a divorce. But again, I think that's the blessing and curse of divorce, is there's so many different arguments and ways to present a case that may be beneficial to one person or maybe not.
That's great. One thing I've seen in my cases over the years is that people assume when we say 50-50 that that means every asset is going to be divided in half, right? Like every
Yes.
checking account gets divided in half, every retirement gets divided in half. But that's not correct, is it?
No, you don't logistically go in and cut everything in half, right? I think sometimes that doesn't make sense, especially given different implications such as taxes on retirement account and penalties that people may have to pay, or capital gains taxes, for example. So I think that a lot of times, instead of actually going through and separating things 50-50, there may be different offsets to different things. For example, I think like if all you had in a divorce was two checking accounts worth $5,000 each, right? You wouldn't actually go in, and I wouldn't give you, Holly, $2,500 of my $5,000 checking account, and you wouldn't give me your $2,500, right? We would just each keep our own, because at the end of the day, we'd still have $5,000, and that's what equal is, right?
Call it a wash.
Exactly. Call it a wash. So much
And the
easier.
other one, yeah, exactly. It's yeah, when you said the word logistics, it's like that's exactly right. Logistics. Like, does it make sense to divide as few accounts as possible to accomplish an equal division, or to divide every single account to accomplish an equal division? It's
Right.
like try to take the path of least resistance, and trying to accomplish what are the goals of the parties, right? If somebody really, really wants to maintain their pension intact and not divide it, and the other party desperately wants to keep the house, you might have a win-win situation
Right.
where both parties get exactly what they want and we don't have to divide two of the assets. Great if it
Mhm.
works out math wise. But certainly it's something that, as you already mentioned, the tax implications and the overall equitable division in terms of math, all of that gets taken into account to make sure it's fair.
Right.
Fair. The four-letter F word in family court, right?
Yes.
Well, very helpful as always, Nikole. I so appreciate these insights into your world of family law, and I look forward to talking with you again soon.
Same. Thanks for having me.
Dividing property fairly is only part of the equation. Many Wisconsin spouses are surprised to discover hidden financial risks that aren't obvious until after the divorce is finalized, and by then it's too late to fix them. So watch this next video and learn the most overlooked costs in divorce and how to protect yourself before you sign anything.